Every day in the USA, people find themselves in court.
Following breaking news this morning out of Stewart County, that's where authorities are looking into allegations that employees of Mimi's Child Care were drugging some of the children they were caring for. The Stewart County Sheriff's Office tells News 2 that 4 employees have been charged in the ongoing investigation. Jamie Clark, Kristen Clark, Jordan Darnell, and Ethan Pulley are accused of giving children a sleep aid known as melatonin without their parents' consent. It was a suspicious parent who tipped off investigators.
When they pick them up, very sleepy afterwards, reports of them sleeping from 11 to 2 o'clock. They'd come in and pick them up. They'd still be sleepy on the car ride back. They'd fall asleep. They was thinking they was playing hard all day.
Investigators say the children ranged in age from infant to 6 years old. The Stewart County Sheriff's Office asks if you had a child who stayed at Mimi's Child Care in the past to please contact their detectives.
For coverage now, dozens of children were allegedly drugged at their daycare. It happened in Stewart County. Tonight, 4 people are charged and parents are asking for justice. News 2's Kenley Hargett is there with details that are shocking both parents and investigators.
Melatonin is a popular sleep aid that you can even buy over the counter. But the issue is, authorities say Mimi's Child Care behind me has given this popular sleep aid to kids for years without parental consent.
So right now we're up to approximately 26, 27 kids over the span of the whole time that they've been open.
Stewart County investigators say even they are surprised to see a place that is supposed to protect kids do just the opposite. Since early March, they have investigated Mimi's Child Care for allegedly giving melatonin to kids.
There are some parents that have stated their children have suffered from possibly this melatonin that they've been given, so we're still looking into that.
I spoke to one mother who says her 2 kids had attended that daycare. She says she's devastated.
I'm still almost at a loss for words about it.
It's not just parents who are upset to hear about the alleged abuse. Many people throughout Stewart County are heartbroken.
Mostly good people down here, mostly retirement people coming in, moving in, because it's a good place to live. And we haven't ever had that happen before, and I hope it never happens again. I mean, those precious children and precious babies.
Here's a look at the 4 people the sheriff's office charged. This daycare will remain closed as the investigation continues. Reporting in Stewart County, Kenley Hargett, News 2.
Stewart County deputies are still looking for children who may have attended that daycare. If you are a parent or a guardian with such a connection, contact them at 931-232-4053.
So my client is going to tender a no contendere plea today, Your Honor.
All right, I've been handed a document indicating that Ms. Darnell is going to be entering a plea under 4035-313. Is that correct?
Correct, Your Honor. State in negotiating this case will offer
You understand you'll have to testify truthfully?
Yes, sir.
All right. Then I've been handed a document indicating that there are 12 counts in the indictment, and I'm not going to, at this point, go through them, but you're going to be entering a plea of no contest to count 2. Count 1 is dismissed. Count 3 is dismissed. But the remaining counts, in each of those counts, you're going to have a count attempted child abuse and receive a sentence of 1 year. And what is the effective total sentence in this case? 5 years. All right. So those are running, some are running consecutive, some are running concurrent with each other, but it's an effective 5 years of probation. Do you understand that?
Yes,
raise your right hand. Let's place you under oath.
Yes, ma'am.
State your full name for the record.
Jordan Hannah Darnell.
Ms. Darnell, you're here today charged with a multi-count indictment involving, and this is the case that involves the daycare center over in Stewart County, correct?
Yes, sir.
All right, and you heard me go through what the effective balance of it is, but have you and Mr. Cox had a chance to go over the indictment, discuss the range of punishment you're facing, the state's evidence, and any possible defenses you might have?
Yes, sir.
Well, it's indicated that you want to enter a plea of nolo contendere What that means is you're not going to admit you did anything wrong, but you're not going to contest the state's evidence. And they're going to tell me what their evidence would be if this case went to trial. Do you understand that?
Yes, sir.
You understand that a plea under this 4035-313 is basically what we call judicial diversion. And I'll get to that again in a moment, but that's a special consideration for someone who has no prior record. You understand that?
Yes, sir.
All right, do you understand that you have the right to plead not guilty and to have a speedy and public trial by jury in this court? You understand if you went to trial, you'd have the right to have a lawyer and have one appointed if you cannot afford your own.
Yes, sir.
Do you understand that if you went to trial, you'd be presumed to be innocent until such time, if ever, the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict will have to be unanimous before you could be convicted of anything?
Yes, sir.
Do you understand that if you went to trial, you and Mr. Cox could confront and cross-examine every witness the state called to testify, and you can bring in your own witnesses by using a subpoena?
Yes, sir.
Do you understand that at trial you would be presumed to be innocent? You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial.
Sir.
Do you understand that if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes, sir.
You understand that by entering this plea of no contest, you're waiving your right to a trial and to an appeal. All I'm going to do is approve what your lawyer has worked out.
Yes, sir.
Do you understand that that's going to result in a number of convictions? Now, I explained to you that this 4035-313 is a process that's only available to people who have no prior record and have some reason why they should be given special consideration. Do you understand that what that means is you're handing me these pleas, and for 5 years you're going to be on probation. If you successfully complete all of the terms of your probation, which does include testifying truthfully against anyone else who might go to trial in this case, then at the end of that 5-year sentence, you can apply to have your record expunged. It won't happen automatically. You'll have to ask the court to do that, but you understand that's an option that you will have.
Yes, sir.
You understand that if you violate that probation and you don't comply with all of the terms, then these will become permanent convictions, and they will be on your record in the future to make more severe the punishment you'll receive if you're ever again convicted of a crime.
Yes,
You
sir.
understand all of that? All right. You understand everything I've explained to you?
Yes, sir.
Do you want to enter this plea according to that agreement?
Yes, sir.
Is your decision to plead no contest today voluntary?
Yes.
Anyone forcing you to do this against your will?
No, sir.
You understand that I can't accept your plea unless I'm satisfied that there is a basis for it and that you are in fact guilty of these charges. Now, how does the state wish to proceed? Since part of this agreement, it's a no contest plea, but part of the agreement is that she'll testify truthfully against the co-defendants if any of them go to trial, correct? So how do you wish to plead? Do you want her to testify on the record and make an allocation right now? Or do you? All right. I want you to listen as the state, and if you'll step to the side, let's let General Allen, whose voice is a little raspy today, let's let her, I want you to listen, because this is what they're expecting you to be able to testify in conjunction with. You understand that? All right.
Your Honor, the state would put on proof that between May 1st of 2021 and March 25th of 2022, the defendant, Jordan H. Darnell, was under the supervision of Jamie J. Clark, a co-defendant in this case at Mimi's Daycare in Stewart County, Tennessee. And during those dates, under the supervision and at the direction of Jamie Clark, Ms. Darnell periodically gave 30 milligrams of melatonin to children under the ages of 8 in the counts listed in the indictment, Your Honor, at Mimi's Daycare. While those children were at Mimi's Daycare as a result of the melatonin, had night terrors, were vomiting, weren't sleeping at night, and it had deteriorous effects on their physical and mental health, Your Honor. And that's what the state would put on for proof. And also, while working there, Kristen Clark and Ethan Pulley and Jamie Clark, Your Honor, did try and take the camera down that had proof of administering of the melatonin, and we're going to hide it from law enforcement. It was eventually turned in, Your Honor, but that is the basis of what the state would ask Ms. Darnell to testify to, and we would also, I mean, it'll be more detailed at trial, Your Honor, but that's the basis of the facts.
All right. Ms. Darnell, I'm not asking, I guess I am asking, normally I would say I'm not asking you to agree with those facts, but you understand that's what the state expects you to testify truthfully to at trial, correct?
Yes, sir.
All right. You understand everything that I've explained to you thus far and what your obligation will be?
Yes, sir.
And you understand if you don't testify truthfully at trial, then that will violate the terms of your probation?
Yes, sir.
All right. Are you satisfied with your attorney's services?
Yes.
You feel like Mr. Cox has done a good job of representing you competently?
Yes.
Mr. Cox, do you know of any reasons you should not enter this plea? Anything further from the state? Then Jordan Darnell in docket number 2023 CR 1, upon your plea of no contest to count 1 is dismissed, count 2, attempted child abuse, you're found guilty, sentenced to 1 year in the Tennessee Department of Corrections, suspended of probation. And that will be a condition of your probation, as you will not be able to work for a licensed daycare center while on probation. Count 4, count 3 is dismissed. Count 4, you're sentenced to 1 year consecutive to count 2 plus costs. Count 5, you're sentenced to 1 year concurrent with count 4, a $50 fine and cost. Count 6, you're sentenced to 1 year consecutive to count 5. Count 7, you're sentenced to 1 year concurrent with count 6 and a $50 fine. Count 8, you're sentenced to 1 year concurrent with count 7. Count 9, you're sentenced to 1 year consecutive to count 8, $50 fine and cost. Count 10, you're sentenced to 1 year concurrent with count 9. Count 11, you're sentenced to 1 year consecutive to count 10, a $50 fine and cost. Count 12, you're sentenced to 1 year concurrent with count 11. This will all be on supervised probation. She'll need to see the probation department before she leaves today.
Your Honor, I may have wrote it in there wrong, but there's only one cost for all of it.
Okay, well, there's several times it's mentioned. I just want to make sure.
There's just $50 fines on the odd counts,
All right.
but then there's just one cost.
Court costs of 1 count. Thank you.